好，歡迎大家出席。麻煩大家全程喺場內就戴口罩啦，保持適當嘅社交距離。終審法院首席法官張舉能會先同大家講幾句嘅，然之後再回答大家嘅提問。唔該 ，CJ。
各位大家好啦嚇。首先好多謝大家出席今晚嘅傳媒嘅簡報會啦。就讓我喺回答大家嘅問題之前講幾句説話。今日係我擔任終審法院首席法官嘅第一日，我獲得信任同埋委以重任我深感榮幸。同歷任嘅終審法院首席法官一樣，我作為終審法院嘅首席法官，我嘅使命就係維護法治，讓司法機構繼續保持獨立同埋公正無偏。今日下午我喺法律年度開啓典禮致辭嗰陣時就扼要咗講述司法機構致力維持嘅3項基本要點，分別就係司法機構必須繼續保持獨立同埋公正無偏，必須由正直同埋願意捍衛權利嘅法官組成，同埋司法機構必須保持專業、高效同埋與時並進。多年嚟司法機構推出咗好多項以提高法庭運作同埋服務方面效率嘅措施，問責性同埋透明度，我哋都係希望提高嘅。當中主要嘅例子包括係民事司法制度嘅改革啦，家事訴訟程序規則嘅全面嘅檢討，呢個檢討仲繼續進行緊啦。持續推行嘅法庭程序數碼化計劃啦，同埋我哋推展咗遙距嘅聆訊。喺大前提係不可削弱司法獨立呢個關鍵嘅大前提之下司法機構樂於聆聽，而且歡迎所有有建設性嘅建議，以進一步改善同埋優化我哋嘅運作同埋服務。我哋十分重視處理針對法官行為嘅投訴機制。自從去年開始我哋已經採取咗措施，將廣受關注嘅投訴個案調查嘅結果同埋理由上載喺司法機構嘅網站。鑑於我哋投訴處理機制受到公眾嘅關注，而且我哋上一次檢討個機制嘅時間係2016年啦，所以我哋將會就呢個機制進行檢討，藉此進一步提高機制嘅透明度同埋問責性。喺我哋嘅檢討過程裏邊我哋會考慮公眾提俾我哋嘅意見嘅。另外一樣嘢啦，就係關於設立量刑委員會而訂立呢個量刑指引呢個社會上嘅一啲建議。我想喺呢度指出，量刑係司法職能嘅重要一環，由法官獨立履行嘅。喺我哋普通法制嘅角度之下上訴法院、上訴法庭喺處理上訴同埋判刑覆核嘅時候擔負重要嘅角色，負責糾正下級法院嘅錯誤，消除下級法院之間判決或者判刑之間嘅差距，同埋發出具權威性嘅量刑指引同埋指導。社會上對設立量刑委員會呢個建議實際全部都係關乎下級法院喺最近呢啲日子就社會事件有關嘅案件若干嘅量刑決定所提出嘅。就訂定呢個權威性同埋有約束力嘅量刑指導，同埋消除各下級法院之間嘅判刑嘅差異呢一方面 藉着上訴同埋呢個判刑覆核呢，我哋認為係更有效同埋更常規嘅方法。上訴法庭呢，到而今嚟講呢，已經一共處理咗呢唔少過8宗源自社會事件有關嘅案件嘅判刑覆核，並且呢就呢類嘅案件呢，發出咗重要嘅量刑嘅指引同埋指導嘅。呢啲指引同埋指導呢，對所有下級法院呢都具有約束力。嗱，我哋嚟緊呢幾個月呢，仲有好多嘅呢類嘅案件，有7宗啊，唔少過7宗嘅呢一類嘅案件呢，我哋上訴法庭呢會處理嘅。咁另外呢，好似我正日晏晝嗰時講到嘅呢，我哋將來有呢啲案件呢嘅時候呢，我哋會加快上訴庭聆訊呢啲上訴或者覆核案件嘅時間。我哋認為咧，呢啲處理嘅方法呢，係能夠最有效率同埋最有成效地呢，回應呢類案件需要訂定量刑指引嘅訴求嘅。對香港嚟講呢，2020年呢係一個特殊同埋艱難嘅一年。我感激司法機構嘅同事呢，不辭勞苦，應對咧2019冠狀病毒病疫情嘅影響嘅案件數量非常繁重所帶嚟嘅種種嘅挑戰嚇。我想特別咧喺呢度提述咧，最近備受關注嘅高等法院司法覆核案件嘅數量問題。司法覆核許可申請呢數量呢，近年的確係顯著嘅增加，但係當中嘅原因呢，基本上完全都係由於呢係免遣返聲請案件嘅司法覆核許可申請嘅。呢類嘅免遣返聲請嘅有關嘅司法覆核許可申請呢，佢個數目呢，由2016年60宗呢，一路跳到咧2019年嘅3700宗。但係其他類別嘅案件，即係唔係呢啲免遣返聲請嘅司法覆核申請案件，其他類別嘅司法覆核許可申請嘅案件呢，實際嘅每年嘅數量呢，一路都係維持喺咧160宗左右嘅啫。嗱，一如以往呢，我哋會繼續盡量善用我哋司法機構嘅人手同埋行政嘅資源，應對呢啲工作，以確保咧司法工作咧得以有效嘅執行。嗱，我會用英文講翻我正話講嘅嘢，然後咧我就回答大家嘅問題。多謝大家嘅忍耐。Now switch to English. Good evening. Thank you very much for attending this press briefing. Let me say a few words in English before taking your questions. I assume the office of the Chief Justice of the Court of Final Appeal today, and I'm honored and humbled by the trust and responsibility that has been placed in me. Like my predecessors, my mission as Chief Justice is to uphold the rule of law and to maintain an independent and impartial judiciary. In my speech at the ceremonial opening of the legal year this afternoon, I outlined 3 fundamentals of the judiciary that we are committed to. That is, the judiciary must be and must remain an independent and impartial judiciary. It must comprise judges who are upright and who are prepared to uphold rights. And it must remain a professional and efficient judiciary that moves with the times. Over the years, the judiciary has put in place many measures to enhance the efficiency, accountability and transparency of our court operations and services. Notable examples include the civil justice reform, the comprehensive review of the family procedures rules, the ongoing project to digitize our court procedures, and the implementation of remote hearings. Subject to the overriding consideration that there can be no undermining of judicial independence, the judiciary is receptive to and indeed welcomes all constructive suggestions on ways to further improve and enhance our operations and services. We attach great importance to the mechanism of handling complaints against judicial conduct. Since last year, we have adopted the practice of uploading the results of investigation into complaints on our website in relation to cases that attract wide public attention. Given the public's attention on our complaints handling mechanism, which was last reviewed in 2016, we will conduct a review with a view to further enhancing its transparency and accountability. Public views will be taken into account. On the suggestion to set up a sentencing council for laying down sentencing guidelines, I would like to point out that sentencing is an essential part of the judicial function, which is exercised independently by judges. Under our common law system, our appellate courts, sitting on appeal or sentence review, play the important role of correcting mistakes, ironing out discrepancies in decisions and sentences amongst lower courts, and giving authoritative sentencing guidance and guidelines. In view of the fact that suggestions for the setting up of a sentencing council all stem from some recent sentencing decisions in the lower courts in social event cases, a much more effective and conventional way of obtaining authoritative and binding sentencing guidance and ironing out discrepancies in sentences is by means of appeal and sentence review. Thus far, the Court of Appeal has dealt with no less than 8 sentence reviews arising from social event cases and given important sentencing guidance on this type of case, which is binding on all lower courts. More cases, in fact no less than 7 cases, will be heard in the coming few months. We will also fast-track the hearing of similar appeals and reviews. We consider this is the most effective and efficient means of addressing concerns over the need for timely sentencing guidance on the type of case in question. 2020 has been an extraordinary and difficult year for Hong Kong. I'm grateful to my colleagues in the judiciary who have been working doubly hard to meet the challenges arising from the COVID-19 pandemic, on top of our very heavy workload. Here, I would like to highlight the number of judicial review cases handled by the High Court, which has attracted some public attention recently. The very substantial rise in the number of leave applications for judicial review in recent years is almost entirely attributable to those relating to non-refoulement cases, otherwise known as torture claims. The annual number of non-refoulement leave applications for judicial review has risen from 60 in 2016 to over 3,700 in 2019, while the number of applications in other types of judicial review cases has remained stable at around 160 per year. We will, as always, continue to make the best possible use of our manpower and administrative resources to cope with such workload to ensure efficient administration of justice. I now open the floor and questions are welcomed.
而家提問嘅環節，咁請先介紹你哋代表嘅機構啦，咁然之後用咪發問，咁每個機構最多3條問題嘅。
你好，張官，商業電台嘅，想問翻三權分立方面啦。其實張官喺過往嘅判詞都有提及過三權分立嘅，但係今次典禮上面致辭就未有提及啦。咁即係三權分立係咪都覺得呢個用詞政治化咗咧？其實都有提過，法庭無可避免都要處理一啲政治嘅案件啦，而個趨勢都似乎越嚟越多。咁預期喺任期之內，法庭面對嘅壓力咧，外在內在係咪都會增加咧，更加大咧？同埋頭先張官都有提到話，現有嘅上訴機制啦，或者係判刑覆核啦，喺量刑方面會更加有效。咁喺司法改革方面咧，會唔會預期任期之內都會係一個比較重要嘅討論咧？馬官退任嘅時候都講過啦，即係輸咗就話要改革，唔係一個好嘅理由啦。唔知你同馬官嘅睇法係咪一致咧？可唔可以講多少少你嘅睇法啊？另外頭先喺典禮上面致辭都有提過話，招聘法官上面都有困難，同埋都見到喺國安法訂立咗之後咧，有啲即係有部分嘅海外非常任法官都辭職啦。即係擔心喺任期之內，即係面對可能尤其是喺國安法實施咗之後咧，會越嚟越難招攬一啲海外嘅法官啦。係咪都反映可能國際社會對於香港法律制度嘅信心下降咧？唔該。
好多謝呢位記者朋友嘅問題啦。咁當然我哋話3條啦，但我就剔到有起碼6樣嘢啦。睇下答唔答得到啦，唔好介意如果漏咗你嘅問題。三權分立呢個好熱門嘅問題啦，就係太熱門啦，就變咗係好政治化。咁咧我就唔適合喺呢多方面評論。但係最緊要嘅對我哋司法機構嚟講咧，我好想強調就係咧按住基本法裏邊第2條、第19條、第85條咧，都提到咧獨立嘅司法權同埋咧司法機構咧獨立去行使呢個司法權去判案。對我哋嚟講，司法獨立嘅去判案咧，呢個係最重要嘅，係最主要嘅，我哋關心嘅事情嚟嘅。嗱，第二樣嘢咧就講到壓力啦，所有工作都有壓力㗎啦。係咁樣甚至乎咧喺法官嘅工作裏邊，有時去判案，判咗嚟嘅結果冇可能係所有人都開心或者滿意，有批評，有唔開心嘅，有説話咧，呢啲係我哋工作預咗一部分㗎啦，呢個係在所難免嘅。咁我哋咧都係做法官嘅咧都有專業嘅要處理呢啲嘅壓力㗎啦。第3樣咧就係上訴同埋上訴法庭嘅角色同埋判刑嘅指導指引。咁我啱啱喺我開場白嗰度咧都講咗，上訴法庭咧有個好重要嘅角色。如果我哋話咧，我哋需要指引，或者咧有啲下級法庭，如果有啲社會人士覺得係判得太重啦、太輕啦，或者係有參差嘅時候咧，呢啲正正就係上訴法庭佢存在嘅其中一個重要嘅功能嚟嘅。咁如果話有好多呢啲案嘅咁樣嘅時候咧，我正話都講過啦，我哋會實際咧我哋處理得好快嘅。實際過去半年咧，我已經講咗咧，有8宗嘅案件咧，我哋處理咗，嚟緊有7宗。當中咧唔係淨係處理個案件上訴或者覆核嗰個案件本身咁簡單嘅。上訴法庭佢嘅功用咧，喺個判詞裏邊咧係講多好多呢一類案件應該點樣處理，着重點係點樣樣。呢啲講嘅嘢咧，對下級法院咧好係有約束力嘅。所以呢方面咧係俾個指引咧係可以好快，亦都咧好有效嘅。嚟緊咧，我哋咧呢一類嘅案件咧，我哋會更加快處理嘅。嗱，你第4樣嘢咧，我剔到咧就係改革啦。咁我已經講咗量刑指引呢方面啦，大家都好關心嘅事情，我哋都好關心㗎，我哋都想盡量回應社會嘅訴求嘅。另外嗰樣嘢就係法官投訴機制嗰樣嘢啦。咁我已經喺我哋今日晏晝嗰個 典禮裏邊嘅致辭裏邊，我亦都正話都再重複咗啦。明白社會上嘅一啲嘅聲音同埋意見，我哋咧亦都係好歡迎所有嘅有建設性嘅意見嘅。但係我哋一定要明白咧，所有嘅改革佢嘅目的係乜嘢嘢？咁呢個一定要翻司法機構啊，因為你講緊司法改革啦，佢存在嘅目的係乜嘢嘢？就係咧秉行公義、獨立嘅、公正嘅、不偏不倚嘅判案。所以嘅話咧，一切嘅改革咧，一定以我正話講嘅司法機構嘅存在嘅使命、目的同埋責任咧為依歸，去衡量每一個改革嘅提議會唔會幫助到我哋更有效、更快捷、更好嘅達到呢啲嘅目的。咁我哋係用呢個角度去睇嘅。講翻嗰個投訴行為嘅處理咧，我已經話咗咧，我哋會係檢討嘅。檢討嘅過程裏邊咧，會考慮社會人士嘅意見。到了檢討有結果嘅時候咧，我哋會咧係適時就公佈嘅。就講咗好多嘢啦，跟住咧又講到招聘嘅困難嗰方面嚇，特別係海外嘅法官。海外法官咧當然係指我哋咧終審法院海外嘅非常任法官。咁咧，大家我希望大家咧可以留意得到啦。特別正話講到啦，話國安法嘅問題。自從舊年國安法之後咧，實際我哋終審法院咧有好多輪嘅處理上訴案件嘅。每一輪咧，實際你留意到咧，都有外國嘅非常任法官嘅參與嘅。當然，由於疫情嘅關係咧，除咗有部分嘅法官咧就要用遙距嘅方式參與聆訊。但係咧，我哋都特別想提述咧，就係咧，我哋當中有2位年紀都唔係話好輕嘅非常任嘅海外法官咧，佢親身雖然疫情嘅關係咧，飛到嚟香港咧，同我哋一齊咧去審案嘅。而嚟緊，我哋今年咧，亦都安排咗咧有海外嘅非常任法官去繼續為我哋終審法院咧同我哋一齊審案嘅。所以我哋對咧終審法院繼續咧可以有我哋自己本身嘅常任法官啦，本地嘅非常任法官同埋咧海外嘅非常任法官咧，我哋咧係好有信心嘅嚇。
或者呢位
張官你好，香港電台嘅想問一問你頭先有提到即係處理投訴法官嘅機制嗰度要提高個透明度同埋問責性啦。其實個大方即係除咗聽意見之外，其實而家司法機構有冇一個大方向咧係會點樣做咧？咁如果提高咗透明度嘅時候咧，即係披露咗一啲喺度處理緊嘅案件嘅時候，會唔會即係變相就造成反而一個壓力咧？同埋之前李慶年法官都講過啦，即係而家下級嘅法院咧面對好大壓力。咁如果提高咗問責性嘅時候，會唔會變相亦都係令到下級嘅法官係個壓力更加大咗咧？同埋你同唔同意即係律政司其實要俾多啲嘅量刑建議咧？呢個係關於司法改革問題。另外就係關於法治信心嘅問題啦。咁即係有市民就話法治已死，亦都有市民話即係法官判得太輕啦，縱容一個暴力咁樣。咁對於一啲無理批評法官嘅一啲嘅言論啊或者行為咧，其實你會點樣處理咧？除咗頭先致辭嘅時候提到話嚴厲譴責之外，會唔會有啲嘅罰則咧？當有一刻咧，你自己都覺得係冇辦法捍衛法治嘅時候，你會點做咧？同埋另外就有一個例子咧，就係今日練錦鴻法官咧就要求一啲戴黃色口罩嘅律師同埋市民咧就離開法庭。其實如果連黃色口罩都係都唔得嘅時候，係咪法官帶頭去政治化咧？將個人嘅政治嘅觀念帶上法庭咧？咁我哋見到今日法官可能包括張官你啦，自己着嘅衫都係一個黑色嘅袍咁樣啦，咁又代表咗啲乜嘢咧？但係使唔使改埋顏色咧？咁樣咁呢啲例子其實係啦，呢啲例子會唔會都削弱咗個市民對法治嘅信心咧？唔該。
好欣賞我哋嘅傳媒同事咧，真係好熱心嘅工作嚇，好踴躍嘅提問。嗱，咁我只係能夠我剔得單嘅啦，答寫得到嘅我答你啦，好唔好？嗱，嗰個處理法官嘅投訴機制咧，我話咗啦，我哋會檢討嘅。檢討嘅目的咧係增加個透明度同埋公信性嘅。咁個方向就係呢兩個方向啦，增加透明度同埋公信性。 大前提咧就係咧一定唔可以影響咗司法獨立。咁呢個我相信大家都會同意嘅。咁你話啊，咁呢啲投訴機制會唔會影響到人哋審緊案啊，俾咗壓力咧？係絕對唔會嘅，因為我指出一點咧，我哋而家嘅機制同埋我哋將來嘅機制一樣噶啦。當個案件仍然係審訊當中嘅時候，甚至無佢審訊完啦，但係仍然上訴期啊嘅嗰啲覆核期未過嘅時候咧，我哋唔會處理嗰個投訴嘅。所以有時咧，你見啊點解有啲投訴好快處理，有啲投訴咧慢啲處理咧？實際就係呢個原因嚟嘅，所以就唔會影響我哋現行嘅案件嚟㗎。咁就又提到下級法院嘅各類嘅嘢啦，投訴嘅機制咧，唔係要嚟影響或者俾壓力任何嘅同事嘅。我哋咧嘅同事都係受過專業嘅訓練嘅，上訴啊或者覆核有時被駁回，有時上訴得直，呢啲係作為法官咧，不論邊個階級嘅法官咧，都有經歷過嘅。呢個咧係我哋習慣咗㗎啦。反而咧從呢啲上訴啊覆核嘅，無論係推翻嘅或者駁回嘅咧，我哋反而咧各級嘅法院各個同事咧喺從中咧就可以咧學習更加咧可以有進步嘅。嗬，嗱呢個第一樣啦。第二樣嘢咧就法治啦，又提到法治已死啊諸如此類嘅嘢。你明白嘅，當然社會人士有時一啲嘅判決未必佢中意嘅時候，未必開心嘅時候咧，佢有感而嘆啦，或者佢有個情緒啦，呢個能夠理解。但係你問我哋咧，我哋係司法機構，我哋咧就絕對咧相信香港係法治嘅社會，有法治嘅。因為咧根本我哋司法機構嘅存在一大目的，或者實際最大嘅目的咧，就係獨立嘅維護司法獨立同埋咧香港嘅法治嘅。咁我哋咧相信咧，我哋做嘅工作咧有一定嘅成效，香港係維持法治，我哋都會盡力去咁樣做嘅。咁所以呢方面咧，我都想講一講，因為當然法治咧有唔同人咧有唔同嘅定義㗎，係咪啊？咁但係一般嚟講，喺我哋從讀法律嘅嚟講咧，有幾方面咧你可以睇到，一般嚟講都係承認考量一個社會有冇法治咧，去睇幾方面嘅。當然有多啲有少啲啦，有唔同嘅啦。但係基本上有幾樣嘢嘅，大家都會同意嘅。第一，嗰個社會係咪法律面前人人平等？嗱，呢個我哋香港咧好好嘅，喺基本法第25條咧寫到明有保障嘅。第二樣嘢睇嘅咧，實際咧就係睇你嗰度啲法律係咪公開嘅咧？係咪透明嘅咧？係咪人哋揾得到嘅咧？係咪朝令夕改嘅咧？定係寫得好清楚嘅咧？咁我相信咧，冇人可以話我哋香港法律咧唔公開、唔透明、唔寫得好清楚。好多案例全部咧都可以有法可依嘅。第三樣嘢好多人睇嘅，你呢個社會有冇法治？你香港有冇法治咧？就問啦，你係咪司法獨立嘅咧？你啲法庭係咪獨立嘅咧？所以呢個係我哋嘅使命嚟嘅，好緊要嘅。我哋維護司法獨立、公平公正，咁我哋係相信有法治嘅。第四樣有啲人講啦，佢咧有冇法治嘅咧？喺英文佢哋用個字叫 thick concept of the rule of law 嘅意思，即係話咧呢個係加料嘅法治嘅概念咧，就係咧呢個法治社會一定咧要保障人嘅基本權利嘅。咁如果用呢個定義嘅話咧，我哋香港咧亦都係保障基本權利嘅一個社會。喺基本法特別係第3章同埋咧人權法裏邊咧，同埋國際人權國際嘅公約對香港係適用嘅咧，裏邊咧都係保障咗香港居民嘅權利嘅。咁如果你從呢個角度睇咧，所以我正話答你咧，就話咧香港係有法治㗎，我哋係會繼續維持香港法治咧，盡我哋最大嘅能力嘅。嗱，第三樣嘢咧就比較啱啱發生啦，詳細情況我都唔敢講，係咪啊？但係咧話戴黃色口罩啊，諸如此類嘅嘢。咁嗱，我唔想評論個別嘅案件嘅做法，同埋特別啲案件咧正在進行之中。但係咧，大家都要明白審緊案嘅時候，我一般嚟講法官佢對呢個審訊嘅程序啊，當中發生嘅事咧，佢有好大嘅酌情權嘅。目的係為咗維護公平公正嘅審訊，所以法官咧佢可能有好多嘅 理由考慮，但我當然唔會評論呢個別嘅個案，亦都唔可以代表個別嘅法官去作答。但係咧，你話到着咩顏色嘅衫啊，戴咩口罩啊，咩顏色嘅口罩啊，或者透明口罩啊，有花樣圖案嘅，咁香港係自由社會，我覺得完全係冇問題嘅嚇。
張官你好，有線電視想問幾個問題。第一樣嘢咧，就想問翻，其實你上任嘅時候咧，即係而家上任嘅時候，你覺得最大挑戰係啲咩嘢？即係想講，即係你而家上咗一個比較三煞位嘅位置啦。而家咁多人會批評一啲司法系統咁樣，你自己感受係點咧？點樣克服呢一啲批評咁樣啦？第二個問題就想問翻，剛才就提到話量刑委員會啦，張官你講到話上訴嘅機制更加有效。想知道咁即係做定係唔做咧？呢個上訴委員會唔做嘅話，係咪單純話加快上訴庭嗰啲處理案件嘅速度就夠咧？呢個第二個問題。第三個問題就想問埋咧，張官剛才講話你相信香港係有法治嘅，咁你覺得回歸以嚟香港嘅法治情況係點樣？變好咗定係變壞咗？個原因係啲乜嘢？點樣體現到係變壞咗定變好咗？你任期之內點樣令到香港法治係維繫到甚至變好啊？唔該。
好多謝你呢三個問題啦嚇。挑戰咁我哋都係人人都面對挑戰㗎啦。我自己上任都一定係要面對好多挑戰嘅。咁所以咧今日喺我嘅第一次嘅法律年度開啟典禮，作為首席法官發表演講嘅時候，我已經講過㗎啦。三樣嘢我哋係好着重嘅，好堅持嘅，就係司法獨立同埋咧公平公正不偏不倚嘅司法機構，呢個第一樣嘢。換句話講咧，呢方面咧我哋會竭盡我哋所能，我哋去做嘅，亦都去維持，亦都係好重要嘅嘢。第二樣嘢咧就係咧，我哋要咧有好好嘅法官，正直不阿嘅法官。因為咧法官咧其中一個最重要嘅工作咧，就係咧維護各樣嘅權利，特別係基本嘅權利。咁我亦都今日晏晝講過啦。咁呢個你都可以話呢個係挑戰嚟㗎，要揾得好嘅法官，適合嘅法官，法官佢又要肯做法官嘅時候咧，繼續做法官。咁呢個從來咧都係要努力㗎。第三樣嘢咧就係咧，我哋嘅司法機構咧要呢。近期都聽得好多呢個四字成語啦，與時並進係嘛？咁呢個係非常好嘅，我係完全贊成嘅。與時並進、高效、專業、有效率，咁我覺得呢個係我任內咧三個挑戰啦。我三樣嘢，我會集中精神咧努力去做嘅，去維持嘅。嗱，第二樣嘢咧，個量刑委員會咧，我主要係講緊而家呢個情況啫嚇，因為而家提議量刑委員會，佢係有原因㗎，唔會係無端端有人咁講嘅，係咪？因為佢見到有社會有部分人士，我哋理解嘅，佢見到有部分案件，佢認為判得太唔適合，或者咧有啲法庭呢個又重啲，嗰個又輕啲，咁佢唔係好明白，有啲混亂，咁呢個係絕對能夠理解嘅，所以咧有啲人士去提出嘅建議啦嚇，我哋都欣賞佢哋提出嘅建議，就話不如你成立一個量刑委員會啦，咁咪快啲俾啲指引，咁啊大家都識得點判啦，係咪？咁所以出發點係為咗解決我哋而家面對嘅得一類型嘅案件嚇，就係社會事件嘅案件啦，佢嘅量刑嘅情況。所以既然係為咗解決呢個問題，我哋一定要諗啦，係咪要點樣搞咧？係咪我哋香港有度都冇嘅要？整樣嘢有咧，人哋有，我哋就要有咧。定係有冇啲方法係簡單嘅，絕對冇爭議性嘅，修改少少、調校少少，就已經達到我哋提出呢個建議背後嘅原因，就係話咧取消呢啲不同法庭嘅有參差嘅判刑啦，或者係要需要一啲權威性嘅量刑嘅指導同埋指引。我特別強調嗰個權威性。因為你無論你量刑委員會點樣設立嘅時候咧，個權威性咧冇可能咧，因為同個上訴法庭佢個判詞咧係相比，因為我哋係個普通法嘅系統嘅一個司法區嚟嘅，我哋嘅有案例呢樣嘢，有樣嘢叫做 case law 或者 doctrinal precedent 呢樣嘢咧，就變咗咧上級法院嘅判咗咧，下級法院要跟隨，呢個有權威性、有約束力嘅。所以呢個第二樣嘢啦。第三樣嘢法治啦，我已經講咗啦。我哋相信咧法治，香港有法治嘅，我哋亦都係為此而努力嘅，盡我哋最大嘅努力嘅。喺回歸以嚟到而家，當然有好多嘅事情嘅轉變，但係你要睇翻我哋正話講嘅，我哋個一般嚟講嘅定義，法律面前人人平等冇改變，法律嘅公開、透明性、穩定性、肯定性 certainty 冇改變。第三樣嘢，法律嘅法庭係公正嘅、獨立嘅。我哋當然係繼續努力啦，去維持法庭嘅司法獨立。第四樣嘢，維護各樣基本權利冇改變，所以我相信咧，我哋會努力繼續維持呢個香港嘅法治嘅。
Mr. Chief Justice, this is Eric from CNN. I've got 3 questions for you. First of all, you emphasized in your speech earlier that unfounded allegations against judges could undermine public confidence in the judiciary. So what would you do when you hear people making claims inside and outside of Hong Kong that you think are unfounded and could hurt the judiciary? My second question is, are you concerned that Beijing might be unwilling to allow some Hong Kong courts to interpret and apply the national security law without interference? My third question is, do you have a red line in safeguarding Hong Kong's judicial independence where you might consider resigning from your position if such a red line is crossed? If so, what is that? Thank you.
Eric, thank you for the questions. Now, the first question relates to unfounded allegations. Now, as I say in my speech this afternoon, we respect fully everyone's freedom of speech and freedom of expression. So it is only in extreme cases that we are concerned about. Normal expression of views can I put it this way? Expression of views in most cases is normal. Whether we agree with the views expressed or not is not the question. The question is to respect each other's right to have different views from ours. Now, but when allegations are extremes and are unfounded and when allegations become personal attacks on judges, now that is not quite acceptable. And when there are threats of violence against judges or doxing for that matter, now these are things that would threaten the independence of the judiciary, and we cannot accept these sort of things. Now, as for the NSL, now about interpretation of the NSL, now the courts in Hong Kong have been given under the Basic Law the independent power of adjudication over cases in Hong Kong, and that includes cases arising from national security law. So there's no doubt about it. In applying the law, and the law itself has become part of our law, pursuant to provisions in the Basic Law. In enforcing and in applying the law, inevitably our judges will have to interpret the provisions in the law. So we will interpret the law just like any other law in question and apply the law in the cases before them. Now, I would, of course, not comment on any specific or particular cases involving the national security law. They are cases pending before a court. It would not be appropriate for me to do so. But in applying and enforcing the law, inevitably, the courts will first have to interpret and understand the law and then apply it. Now, as to red lines and so forth, now I would rather put it more positively. It is my mission it is my mission, as I say, to do my utmost to uphold the independence and impartiality of the Hong Kong judiciary, the purpose of which is to maintain the rule of law and to administer justice in cases in accordance with the law, the facts and the evidence. Now that is my mission, and I will do my best to fulfill my mission. Thank you.
下一條問題，白色衫嘅。
張官你好，蘋果日報。啱啱張官你都提到啦，即係都好強調你仲相信香港有法治啦。咁你都提到其中一個條件咧係香港嘅法律係咪公開啊透明啦？會唔會朝令夕改或者寫得唔清楚啊？但係咧呢一啲嘅正係即係外界對於國安法一啲批評啦，即係覺得佢寫得唔清楚啊咁樣。你覺得其實國安法咧對於香港嘅司法制度啊，有冇一個影響喺度咧？另外特別係佢當中即係有規定啦，啲案件係可以即係香港發生都好啦，都係交翻去內地嗰度審嘅。咁你覺得呢個有冇違反到你即係好強調基本法裏邊都規定嘅，即係或者係保障嘅一啲嘅獨立嘅終審權啊，或者係司法權咧咁樣？唔該。
多謝你正話呢個問題咧，都係講緊國安法啦。嗱，我講過啦，國安法咧有案件嘅嚇，喺我哋法庭嘅處理緊嘅，所以我唔會講個別嘅條文啊，因為咧一定唔可以影響我哋法庭嘅判案嘅。但我講過咧，國安法咧係已經咧係根據基本法嘅條文咧，成為我哋香港嘅法律嘅一部分嘅。咁我哋咧嘅法庭咧會按我哋一向嘅法律啦嘅去理解、去詮釋呢個國安法同埋應用佢嘅。當然國安法大家都明白係內地嘅法律啦，同我哋香港嘅立法嘅法例咧係有部分咧未必完全一致嘅。但係呢個唔成問題嘅。實際你要相信我哋香港嘅普通法嘅呢個制度嘅，我哋香港嘅普通法嘅法庭咧，即係可唔可以用呢個成語咧？身經百戰嘅，因為對咧解釋各類唔同嘅法律咧，係有好多嘅案例嘅經歷啦，無論本地嘅或者其他嘅，幫助我哋去點樣解釋嘅唔同嘅法例嘅。我哋亦都咧積聚咗好多年嘅解釋嘅基本法嘅裏邊嘅條文啦嘅一啲經驗嘅，我哋都會用同樣嘅方法，用同樣嘅原則咧去解釋呢個國安法嘅。咁至於佢裏邊有其他嘅一啲嘅特別安排，你正話實際係提到咧，佢第55條裏邊講嘅安排咧，咁我講過啦，我唔評論咧國安法裏邊嘅任何條文嘅具體內容啦，呢個係唔適合咧喺我而家喺呢度做嘅。多謝你嘅提問。
或者後邊Chris。
Hi, Mr. Chen. This is Chris from the South China Morning Post. My first question is the same question I put it to your predecessor, Mr. Justice Ma, the other day. So, given the enactment of the NSL, which I think the reporter just mentioned, that basically allowed Hong Kongers to be sent to mainland for trial, and then also stripped away some of the Hong Kong's court's ability to scrutinize certain matters such as surveillance and mainland officers when they're enforcing duties in Hong Kong. How do you still convince Hong Kong courts can give full protection to Hong Kong residents here? And the second question is relating to a question about pressure you just answered earlier. You were saying, the judges will have work pressure. What about pressure that comes from the political side of things, with the perceived tightening grips from Beijing and also this increasingly opening social divide because of politics that's been happening in Hong Kong? How would you deal with all this pressure, and how would the judiciary under you deal with all this pressure? My last question also is related to NSL. You just mentioned that you're quite confident that the Hong Kong judiciary will still be able to hire judges from overseas, and the CFA will still have MPJ from different jurisdictions and common law jurisdictions. Can you tell us what about, are you confident that in the time to come, will these foreign judges be presiding in any of the national security law cases? Also, we've still not seen a list of the designated judges. Any foreign judges among that list of designated judges? Thank you.
Yeah. Now, thank you, Chris, for the questions. Now, again, the national security law. I fully understand that people are interested in the law and its implications. However, as I have just said in answer to questions raised by one of your fellow reporters, now I will not comment on any specific provisions in the NSL for this simple reason. The NSL itself may well come up before the court for adjudication. In fact, some of the cases have already reached some of our courts at a very preliminary stage. So it would not be right for me to preempt any decisions in relation to any provisions in the NSL, speaking in my extrajudicial capacity. So because I'm now speaking as the Chief Justice in my administrative role, I'm not sitting as a judge in the CFA as such. So I'm afraid I will not comment on the provisions in the NSL. Now, the second question relates to political pressure. Now, political pressure is just one form of pressure that judges face and have to deal with. So we all do our best to deal with these pressures. But one important thing. So if a colleague were to ask me for some advice, I would surely give him or her this advice. Never mind the pressure. Never mind the type of pressure. Never mind the source of the pressure or the origin of the pressure or where the pressure comes from. Focus on your own case. Focus on the law. Focus on the issues. Focus on parties' arguments. Focus on the evidence. Focus on the facts. Never mind what people will say about your decision. You just decide the case regardless, according to the law, facts, evidence, argument. The rest you don't care about. You don't care. Well, I shouldn't say you don't care, but you just disregard. Now, I think from my own experience, that is a good way. I can't say it is the best way, but that is a good way of dealing with work pressure. Now, of course, I've mentioned about the role of the Judicial Institute in my speech. Now, one role that the Judicial Institute can play is to organize seminars and workshops to help colleagues to deal with all kinds of work pressures, including political pressure that you mentioned. Now, about overseas MPJ and the designation of judges under the NSL. Now, as you all know, now the designation of judges for the purposes of hearing NSL cases is the responsibility of the chief executive. But what is important to note is that according to the law itself, only judges who have been appointed in accordance with the provisions in the Basic Law, particularly Article 92 of the Basic Law. Only those judges are qualified to be designated. So, of course, Article 92 of the Basic Law says that judges are chosen on the basis of their judicial and professional qualities. So that is a very important point to bear in mind. So whomever may be chosen, he or she will by definition be a judge who has satisfied the requirements of Article 92. Now, and don't forget this one other provision in the Basic Law, which is Article 104. Now, 104, the significance of Article 104 to us is that Article 104 imposes the requirement that all judges, when they assume office, they must take the judicial oath. And the judicial oath requires the judge to administer justice fully in accordance with law, without fear or favor, self-interest or deceit. Now, I think that is the greatest guarantee in relation to the independence and the impartiality of our judges. Whoever the designated judges under the NSL may be, he or she or they are bound to be judges who have taken the judicial oath, and that is where we get our comfort from. Thank you.
嗰邊最邊嗰個男仔戴口罩。
張官你好，NTV。首先咧，想問翻咧，就係其實喺你嘅上任，即係馬道立法官咧，其實任內咧就有2次人大做咗釋法嘅。咁想問下咧，其實你覺得咧釋法呢件事，即係尤其是可能喺呢啲法院作出判決之前，有人大去作出釋法嘅話咧，其實會唔會影響到司法機構去作出佢哋嘅判案？其實會唔會因為咗避免去即係進一步司法進一步受到壓力啦，而去影響咗法院本身嘅判決啦？第二咧就都係想問翻國安法嘅問題。啱啱其實都有行家提到一啲關於指定法官，而好似張官你自己都講過，其實一個地方有冇法治其實好睇嗰個透明度。咁其實依家國安法之下有指定法官，而依家香港市民係仲未知道成個指定法官嘅名單係點嘅時候，其實呢一個制度係唔係足夠透明咧？咁其實你咁係咪仲係說服到即係廣大嘅市民其實係香港係仲有法治啦？跟住最後咧，都係講翻一啲市民同埋司法機構中間嘅信心嘅問題。咁就係其實依家唔少市民咧都覺得越嚟越對司法機構係失去信心嘅。咁其實即係張官覺唔覺得呢一個情況係需要改善啦？其實如果要改善嘅話，點樣改善啦？唔該。
多謝呢位記者朋友嘅提問啦。你第一條咧就問到釋法呢個問題係咪啊？嗱，釋法咧我哋一定要明白嘅。人大常委會佢嗰個釋法嘅權利係喺國家嘅憲法同埋喺我哋基本法第158條咧都有清楚嘅提及嘅，所以釋法咧係喺我哋香港特別行政區嘅法制裏邊咧係其中一環嚟嘅。咁所以釋法嚟講係我哋香港嘅法律嘅一部分嚟嘅啦。所以就釋法，如果有釋法嘅時候，法院就一定要跟從。咁呢個係我哋遵守香港所有法例、維護基本法嘅其中一個責任同埋工作嚟嘅。咁樣當然你話釋法嘅情況點樣啊？咁呢個唔能夠籠統嘅講嘅，你要睇下個具體嘅情況，你牽涉咩案啊？幾時釋法啊？點樣啊？個內容啊？爭議係乜嘢嘢啊？嗰啲嚟定㗎，咁唔能夠一概而論啦。嗱，你講到個都係國安法啦，知道大家都好留心嘅，亦都提到話嗰個透明性。嗱，呢度咧有少少要大家分開先。我講到法治嗰陣時咧，係講緊法律嘅公開性，即係法律啊，即係香港有咩法例啊？咁你喺邊度揾得到㗎？香港有冇案例㗎？案例有冇公開㗎？法庭判咗啲乜嘢嘢啊？知唔知佢講咗啲乜嘢嘢嘅理據係咁樣解？嗱，呢度所以少少唔同嘅。你啱啱個題目咧就係講緊個委任法官嘅名單有冇公開呢樣嘢，咁啊少少同我正話講嗰個法治嗰樣個法律要透明啦，一啲咁多唔同。但係咧明白嘅，即係背後都係希望啲嘢知情權多啲啦，透明度高啲啦。呢個我都好認同嘅，我哋都好認同。但係大家要明白，委任呢個designated judge， 即係呢個特別嘅指定嘅法官，喺國安法裏邊嘅指定法官啊，指定嘅權力咧喺行政長官嗰度㗎。咁公佈呢個邊個係得到指定嘅時候咧，呢個當然係行政長官 佢會做嘅事情啦，我哋係尊重佢做嘅事情嚟嘅。但係好多時你話啊，佢未有宣佈嘅時候咧，都唔緊要㗎。你到案件審嗰時咧，你根本知道咧，佢審得嗰個法官咧，個一定係指定法官嚟㗎啦。咁只能夠咁講啦。第三樣嘢，你話到公眾信心對我哋司法機構下降。我希望你係錯啦，我希望唔係啦，但我又唔知道啲調查點啊、民意啊，或者你問邊個啊咁樣。咁但係無論下降啊、上升啊、維持不變都好啦，我哋嘅責任、我哋嘅使命咧，就係盡我哋嘅能力，盡我哋最大嘅能力，我亦都可以再重申，盡我哋最大嘅能力咧，維護香港嘅法治，維護我哋司法機構嘅獨立同埋公正性。係咧維護咧我哋咧所有喺法律上特別係基本法裏邊咧保障我哋嘅各樣嘅基本權利。咁呢個咧我哋可以好肯定嘅講嘅。多謝你嘅提問。
好我哋最後兩個傳媒啊，前面呢個藍色衫男士。
係你好，香港01嘅就住咧頭先有提到即係都係國安法嗰方面嘅問題啦。因為有提到國安法已經成為咗一個法例啦，咁但係其實佢成個立法嘅過程咧，似乎都係冇乜透明度咁樣嘅。你認為即係亦都因為咁咧，令到香港市民即係對於即係成個司法制度咧有啲即係擔憂咁樣，即係會唔會日後又會有其他嘅法例入嚟，即係亦都造成咗一個所謂朝令夕改嘅問題啦。頭先你提到即係你認為法治咧需要有即係4個指標咧，其中一個就係會唔會朝令夕改咁樣？即係你認為呢方面係咪即係大家透過對於法官嘅信心就足夠去應付嗰樣嘢咧？第二就係法治喺你嘅眼中，其實即係你可以做嘅嘢係咪就只係維持司法獨立就係唯一可以做到嘅事咧？
係多謝呢位傳媒朋友啦，多謝你嘅提問都係翻去我哋今晚熱門題目啦，國安法啦，係咪？嗱，你話個國安法嘅立法過程係點樣？咁當然國安法喺內地立法啦，佢根據內地嘅一般嘅做法程序，咁咧我哋係明白知道㗎。咁樣就係你話佢朝令夕改，我又睇唔到佢點樣會朝令夕改。我唔呢個睇唔到。嗱，國安法已經立咗啦，喺度啦，咁條文亦都係好清楚寫明㗎啦。咁呢個反而咧個情況咧就係我哋咧好似所有嘅新生事物啦、新嘅法例一樣，咁我哋法庭咧會慢慢藉着有案例咧累積經驗，然後咧就係應用呢方面法律。當有多啲案例嘅時候，但凡新嘅嘢都明白嘅，有好多未必係明白啊，或者唔係即時可以理解得到。咁有啲嘅諗法，甚至乎有啲想法，呢個好自然嘅事情。但係呢個同所有新嘅嘢都係一樣㗎啦。慢慢你熟習咗，見得到嘅時候咧，大家開始有個感覺或者有認識嘅時候咧，我相信係會好啲嘅。嗱，你話司法法庭司法機構係咪淨係做到維係司法獨立咧？咁我諗就唔係淨係維係到司法獨立，但係司法獨立係最緊要嘅嘢之一。司法獨立係黐住咗、楞住咗實際法治嘅。你有司法獨立呢個咧，法治咧就要可以達成得到啊，容易好多啦。咁嘅時候咧，呢個係好緊要嘅，對我哋嚟講，我哋會盡我哋嘅能力捍衛法治，維係咧呢個司法獨立，保障香港市民嘅權利啦。呢個係我哋嘅使命，我哋嘅責任，我哋會盡力做嘅嘢嚟嘅。多謝你嘅提問。
好，最後一條，最尾。
Thank you. This is Greg Terode of Reuters. Chief Justice Joan, could you perhaps explain a procedural point for us? That is the circumstances under which somebody might be taken to the mainland for trial under the national security law. Which institution would decide that, and would you expect the Hong Kong judiciary to be consulted, or at least asked whether you would be able to handle the case first? Thank you.
No, thank you for this question. Now, it relates to the provisions, specific provisions in the NSL. It relates actually to Article 55 of NSL. Now the provision says what it says. Now it is not for me here in a press briefing to, as it were, to construe or to give an interpretation or to work out the meaning of a provision like that. Now that is not the function of any judge in his extrajudicial capacity. Now this provision is, and when it comes to the court will certainly have to look at the provision and where the issues require, deal with, interpret, and apply the provisions in questions. So I think that is the best I can do for you. Now, because and another reason why I'm not commenting on the content of the law is this: that the NSL law, there are cases concerning the NSL which do come before our courts for adjudications, and they are pending before our courts. So it is not right for me to give any extrajudicial views, i.e. views expressed other than during actual court hearings or in judgments in relation to the provisions of the NSL. So thank you.
好多謝大家，咁今日記者會節結束啦，唔該晒。
多謝大家，好。多謝大家，拜拜。